It was one of the most discussed and debated bills in this record-setting legislative session. Ultimately, lawmakers and the governor decided, to make it more difficult to get a voter initiative on an Idaho ballot. That was the way to go. Today, the Idaho Supreme Court disagreed with that assessment. The unanimous ruling, which overturns Senate Bill 1110, it claimed it was unconstitutional. Before this session, groups had to collect signatures from 6% of registered voters in 18 of Idaho's 35 legislative districts. Senate Bill 1110 made it so signatures are required from all 35 districts and 6% of them. Not an easy thing to do, which is why, almost immediately after it was signed into law, Reclaim Idaho, the same group to get Medicaid expansion on the ballot back in 2018, they filed a lawsuit against Secretary of State Lawrence Denny to stop the bill from becoming law. Today, the Supreme Court agreed with Reclaim Idaho. Yeah, the law does make it more difficult to get voter initiatives on the ballot. And in their opinion, by giving every legislative district veto power over qualifying initiatives and referenda for the ballot, the ultimate effect of Senate Bill 1110 would be to prevent a perceived yet unsubstantiated fear of the tyranny of the majority by replacing it with an actual tyranny of the minority. Essentially, one district could determine if an initiative gets on the ballot or it misses it completely. All 5 justices signed on to that ruling. Not that everyone outside of the court agreed, of course. Speaker of the House Scott Bedke said this after the announcement: these changes to the voter referendum would have served to increase voter involvement and inclusivity, especially in the corners of the state too often forgotten by some. We believe all 35 legislative districts, every part of Idaho, should be included in this important process. Ultimately, the Supreme Court apparently disagrees, and they are involved in the process when they actually get to vote on whatever initiative makes it to the ballot. So they're saying they're not mad, they're just disappointed. The court has restored the previous version of the law, where groups, again, need to collect 6% signatures from registered voters in just 18 of the districts. The opinion also ordered the state to pay Reclaim Idaho's attorney's fees, which I guess it's a good thing lawmakers voted to replenish that legislative legal defense fund with $4 million this past session, an account that seems to have a lot of withdrawals lately.